Do we file a claim? Probably everyone's favorite topic, insurance or any subset of insurance. My name is Elina Gilbert. I will be your presenter today. And before we get started on the actual presentation, as most of you know, we will have a moment of silliness, and I will go through some housekeeping items, which if you've ever been on one of our webinars before, you probably have this memorized. So you can, check out for a couple minutes and look at Happy Harold or whatever his name is. So for those of you who have not done a webinar before or need a refresher on how this works, the bulk of your screen should be my PowerPoint presentation. You should be looking at Harold, who's very happy. All right, on the bottom right-hand side, you will see the presenter. That's me, hello. And on the left side of your screen, you should see a few little options to click on. If you look at the question icon, which is the one with the word bubble and a question mark in it, as we go through the presentation today, and you have questions that pop up, since we save them until the end of the presentation, just type those in under that question mark bubble. And then at the end, there should be some time left for us to be able to go through and answer most, if not all, of those questions. Sometimes people put it under the other bubble. It's easier if we just have them all in one spot. So if you could just do it under the question mark, that would be perfect. All right, you are going to get a CMCA certificate for 1 credit hour. It is going to be generated automatically as soon as we get verification of people's attendance. So you will either have it today or tomorrow. If you don't see it come through the email by tomorrow afternoon, please, shoot me an email or give us a call, and we can see what happened if it got stuck in cyber world or something like that. A few other things. If you have any technical difficulties as we're going through this, there's nothing I can do on my end about it, and I don't know anything about computers, which I know it's hard to believe, but there's nothing I can do on my end to help. But you can reach out to Sean Sanders, who is our amazing education coordinator. You can either call him directly at 303-991-2076, or you can shoot an email to education@altitude.law, and you should be able to get some help to the extent there's anything going on our end that we can fix for you. We are also working on our 2022 education schedule, and I anticipate that's going to be on the website probably within the next 2 months or so, 3 months max. So we're super excited about 2022, and I know it seems early, but goes quick, right? So 2022 education coming soon, and I'll be on the website. All right, so without further ado, let's go ahead and get into kind of the bulk of the presentation. And, regardless what aspect of insurance we're talking about, I always want to start off by talking about insurance itself and what it really is. We all kind of know what insurance is. We know what it's supposed to do. But I think it's important to understand that kind of from a legal perspective, at least, it's a contract. It is a contract that's perhaps the least understandable of any contract your association might enter into. And so I take pride in saying that insurance contracts are more complicated than any attorney contract. So yay, we're not the worst. So it is a contract. And the purpose of the contract is to transfer risk. In other words, the risk of what? The risk of damages, the risk of injuries, the risk of something going wrong, the risk of liability. We're transferring all that risk to the insurance company. So what does that really mean? It means the insurer is saying, okay, we will take on this risk. So if something goes wrong and, you know, something happens to the property or you get sued or whatever, we are going to pay the damages. We are going to pay to defend you, association, and so you don't have to worry about coming up with the money for all of this stuff. So we will take on that risk in exchange for a very, very small price, right? Whatever that small price is, I'm sure you guys have a line item for it in your budget, and it's not as small as, you know, as we would like it to be. And the other key, sorry, to the contract is that, of course, the insurer will cover you as long as it is something that is covered under the contract, under the policy. So kind of with that in mind, let's also take a quick peek at the general types of insurance. Now, we can have like a 5-hour class just talking about insurance and all the nuances. Today is not going to be that day you can breathe. Whew. All right, today's not that day. But I think it's also important to understand that insurance, there are several kinds of insurance. And when we talk about filing claims, most of the time associations have the most difficult decision when it comes to the property claims. Those are the claims where there's a water leak and there's damages, there's a fire and there's damages, someone's pipe exploded. And associations a lot of times, as you know, have a hard time figuring out, okay, what do we do with this? Is this a claim? Do we file it? What happens if we don't? But then we also have a commercial general liability, CGL, and that's a liability policy. So there's really two kinds of policies. There are property policies, which is the insured property, which is the community. There's something happens to the property physically, something happens to it. Then there's the liability lines. So that includes your commercial general liability, it includes your directors and officers, it includes your fidelity. So basically all these other forms of insurance are typically liability based. And liability based policies simply mean that they are pertaining to allegations of wrongdoing, okay? There has to be some sort of an allegation that someone did something bad, someone didn't do something they were supposed to do, someone did something wrong, and that's what those policies are based on. So commercial general liability, those of course are your slip and fall claims. This isn't where the community is damaged. This is where a person is injured or someone, their personal property is damaged and they want to blame the association for the damages. Directors and officers, very similar, but that pertains directly to, you know, the board members, the officers, managers are covered under D&O liability, you know, things like that. And then fidelity is theft of money. All right. So those are general types. There's obviously a lot of subcategories here, but again, this isn't the kind of class where we're going to go into that. But I didn't want to delineate between the property-based versus the liability-based policies because we have a slightly different analysis when it comes to a liability claim versus a property claim. So I'm going to talk about the liability claim first because while I say it's easy on the slide, it's really not that easy, but it's a lot easier than property most of the time. So the first question I typically say is, has the association been sued? Have you been sued? Has somebody actually filed a court action against you and you've just been served and the association is named in the lawsuit? Maybe individual board members are named in the lawsuit. Maybe the management company is named in the lawsuit, but there is a lawsuit out there. And that lawsuit will most likely want something, right? It's going to ask for things like, you know, I was damaged, my property was damaged, I want this much money from the association owes me this, the association needs to replace X, you know, whatever it is, there's going to be some allegation that the association did something wrong. And usually these types of complaints have more than one allegation. Usually, you know, they'll throw everything they can think in there and hope something sticks. So if the association has been sued, I usually say, hey, no brainer, turn it over to insurance, because you need your insurance carrier to assign an attorney to defend you in the litigation. So A, the association isn't spending its own money on legal fees. And B, if there's any damages awarded, hopefully insurance covers that as well. Okay. And then the next kind of category that usually we see is a demand for, payment of medical bills associated with an injury in a common area. That's more like, your slip and falls. Someone falls and injures themselves and they want their medical bills paid. Sometimes you will see a demand come directly from the homeowner or the resident, whoever was injured. And it's basically like, here's a copy of all my medical bills, pay them. And then if the association says, no, screw you, eventually there's going to be an attorney and they're submitting it saying, hey, pay these or turn them over to your insurance carrier, or we will turn them over. And in those cases, you do want to turn those over to your liability carrier, because that is one of the reasons you have a liability policy. It is to protect the association from things like slip and falls and other types of injuries on the common area where someone is trying to blame the association for their inability to be more graceful. So one thing I do want to mention about this first little check mark, has the association been sued? There are always going to be exceptions. So if you're sitting there thinking, oh, well, you know what? Yeah, I mean, maybe we'll get sued, but what about this? Or what about this? Does this change anything? I mean, there's always going to be some sort of circumstance that could change something. But one circumstance I do want to quickly touch on is when the association gets sued in small claims court. If any of you have ever had your community sued or been named in a legal action and it's in small claims, most of the time, or a lot of the times, there are no claims filed with the association's liability carriers. And that is because in small claims, the dollar amount of damages is capped and it's not that high. And also a lot of people believe that, well, if I get sued in small claims, I can't have an attorney. And so what's the point of submitting a claim to insurance? Well, first thing is, if you are sued, if you are a defendant in small claims, you actually can have an attorney defend you. It's only if you're suing someone, if you're the plaintiff and you're suing someone in small claims, you cannot have an attorney. But the defendant can then decide to have an attorney. So, with small claims type lawsuits, don't assume you can't have an attorney represent you, because you can. And sometimes the dollar amount is just so small, you're thinking it's not worth, submitting a claim, because what they're asking for is far less than even our deductible. So what's the point? And usually that's accurate. However, we always want to think ahead and think, is this something that's like a highly contested issue that is likely to be appealed? Because if it's appealed and we have not submitted a claim for the original complaint, insurance is not likely going to pick it up for the appeal portion, because there is a duty in insurance policies to timely submit claims. Now, what's timely? That depends on the policy and how it's defined, but usually it's, if you're getting sued, it's before you kind of get into the bulk and the meat of the lawsuit. If you're already going down the road of having, the association's attorney represent you as far as like, your counsel, and not someone who insurance assigns to represent you, then chances are you're not going to be able to submit a claim later on. So just food for thought. A liability policy really is going to come down to, have you been sued? A lot of associations want to turn over, you get a letter from an attorney, and the attorney's like, you need to pay my client blah, 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 all this money because you did something wrong, or we're going to sue you. And a lot of times associations turn those letters over to insurance, which is a good thing, because you want to give insurance a heads up that a claim may be coming down the road. But the letter itself does not create a claim, because what the insurance companies want is a lawsuit. They're not going to give you a claim number, or they're not going to actually open a claim. They're not going to assign an attorney until you've been sued. So again, important things to remember. All right, but let's get to the meat of the analysis here, because really I want to focus on property claim submissions. those are the ones where we get the most questions, the most pushback, the most, I think, misunderstanding as far as what is the association's obligation and how do we figure it out? So what I want to do is go through a series of 3 questions, and you will need to look at each of these 3 questions, whether you're doing it yourself or you're doing it, through your attorney or through an insurance representative. But these are the 3 questions that have to be answered in order to determine if a claim should be submitted on behalf of the association. So the first question should be, what caused the damage? We don't always know, right? Like sometimes something happens and we don't really know until we investigate why it happened. I always think now of the Florida condo building collapse. I mean, when it first collapsed, nobody knew anything, right? There were certainly people assumed things, but nobody knew until there was an investigation. Nobody really knew why it collapsed. So again, we don't always know what causes the damage. But if we do, what we're going to be looking for is whatever caused the damage, quote unquote, an insurable event. And I know what you're thinking. You're probably thinking, well, how the heck would I know if it's an insurable event? Well, you may not. You may not. There are some typical things that are covered and are universally defined as insurable events, and there are certain things that are universally excluded from being insurable events. But outside of those parameters, you are likely going to need to reach out to your insurance professional to say, hey, this is what has happened. Would this constitute an insurable event? But some rules of thumb as far as insurable events. Wear and tear is never an insurable event. If something happens to a building just because of its age, it's not, like a failure to maintain, it's not an earthquake, it's not a fire, just age, that is not going to be considered an insurable event. Insurance carriers are not in the business of maintaining our property, right? Which is really what wear and tear is. It's part of maintenance. If you keep maintaining something, you shouldn't have a whole lot of wear and tear. So insurance is not in the business of maintaining and fixing things when an association failed to do it all along. So wear and tear is not something that you're ever going to have covered. But things like catastrophes, acts of God, those are the types of things that insurance is, at least property insurance, is really meant to cover. Your storms, your fires, your hurricanes, the crazy idiot drunk driver who crashed right into the garage. There's a lot of things that can happen. And the way it's been told to me by several insurance brokers in the industry is that insurance is going to cover everything except the stuff that's excluded. All right. So that essentially means you have to go straight to the exclusions part of your policy to see what events are excluded from being insurable events. And like I said, that is going to be things like wear and tear. It's going to be things like if someone intentionally did something, that damaged the property, you punched a hole through your wall because you were angry. Sorry, that's not going to be covered by insurance. So again, those are things that you just kind of have to know that wear and tear, intentional stuff is, not going to be covered, while things like, storms, fires, that type of stuff would be covered. Now, negligence. I'm going to harp on this. I'm going to harp on this throughout the class. And the reason is because so often I hear board members, managers saying, well, why would we submit a claim when it's the homeowner's fault? I mean, the homeowner started the fire because they didn't put out their cigarette. The homeowner left their water running and forgot to turn it off and it flooded their unit. Why would we submit a claim because of that? That's just stupid. Well, the answer is no, it's not. And yes, that just because someone was negligent, that does not mean it's not an insurable event. In fact, I always like to say that insurance really is there to help protect us from our own stupidity, because so many problems, so many of the events that cause damage are due to someone's oversight, negligence, not paying attention, stupidity, call it what you want. And the pushback from boards especially is it's not fair to the other homeowners because now, because of this one person was negligent, so now everyone else has to suffer if we submit a claim because our premiums are going to go up. And that's not fair, so we shouldn't have to do that. Again, it kind of sounds good at first, but it's not accurate. The whole point of insurance in a common interest community is the law, Iowa, considers insurance to belong to the homeowners. There's no really such thing as an association policy. They're all homeowner policies. Why? Because who pays for the insurance? The association doesn't really have its own money. The money it has comes from all the homeowners collectively. And so part of common interest community living is that we share in the good, we share in the bad. So we all pay towards insurance, which means every single homeowner in the community gets the benefit of it. And if I do something stupid and start a fire and the association has to submit a claim, yeah, other people are probably going to be negatively impacted if our premiums go up, but that's what they bought into when they bought into the community. So think of it this way. You have a family and you have property insurance on your individual home. Let's say you live in a single family community, you got the parents, the children, whatever else. One day, the dad does something stupid. Sorry, gentlemen, I'm focusing on the dad. The dad does something stupid and causes a fire. All right, so guess what? They have insurance. Insurance is going to fix the house. They're going to rebuild it. They're going to do whatever they need to do that. But the premium is most likely going to increase. So it doesn't just increase for the dad, it increases for the mom, it increases for the kids because it's one policy and they know that that's what's going to happen. It's exactly the same analysis in a common interest community. Larger, but exactly the same. They're in it together. It's their policy and any one of them can impact the policy, anyone. So when you guys hear about negligence or something being the homeowner's fault, don't let that skew your analysis of whether or not a claim needs to be submitted. It's completely irrelevant 99% of the time. Question number 2. What was actually damaged and who insures those damaged components? So, okay, we had a fire. Great, we know a fire is an insurable event. What was damaged in the fire? What needs to get fixed, right? Is it the carpeting? Is it the drywall? Is it, the drywall and the paint and all the cabinets? I mean, what are all these things that are going to need to be repaired? And once we know what all these things are that need to be repaired, we need to figure out who has that obligation. Okay, who has the obligation to insure those components? So how do we know? How do we know who insures them? Well, most of the time that's, it comes to the attorneys. Hey, who insures all this stuff? And the attorneys are going to say, well, let me look, at the reports to see what's damaged. Let me cross-reference that to your declaration. So the obligation to insure comes from your declaration. It comes from Kiowa if you were created after 1992, and sometimes it comes from common law. So most folks are not attorneys that are sitting on the boards, and even if you are, it depends what area of the law you practice in, and you may not know exactly what components the association insures. Maybe you roughly know, but sometimes, you got to know the specifics. The drywall, what about the wallpaper on the drywall? So what about the cabinets? Do we insure the cabinets that were originally installed or the ones that were upgraded by homeowners? There's a lot of different things to ask. And so, like I said, for the most part, this is when most boards will reach out to the attorney and say, okay, help? What do we insure? In the alternative, I know associations that have maintenance and insurance charts that have been prepared for them by their legal counsel, which summarizes the insurance obligations and the maintenance obligations of all the various components in the community. Those charts are really helpful in these types of situations because you don't have to call the attorney every single time you have a question. You can say, okay, we had the drywall damage. Let's find drywall. Let's see, owner or association, owner or association. We had the light fixtures damaged. Okay, find fixtures inside the unit. Now, who's got that obligation? Those are great tools. If you have one, I'm sure you can attest to the fact that it's very helpful and it cuts down on calls to your attorneys. If you don't have one, talk to the associations of managers that do and have dealt with them. They're great tools. The other thing with maintenance and insurance charts is they are, most of the time, they are submitted to the association's insurance carriers, their agents, and the agents actually use those charts to pinpoint exactly what the association is going to insure. Because the way property insurance works, if you read through the policy, you're not going to see a list that says the association is insuring the windows, the association is insuring the doors, the association is insuring the electrical panels. You're not going to see a list. You're going to see an address. This is the property the association insures. And what happens is insurance will insure whatever your declaration requires it to insure. They're never going to list it out because that's more of a legal analysis. So a lot of time what happens is your insurance brokers are not attorneys. They're going to look at the declaration and they're going to say, yeah, I think it means this. And they're going to err on the side of caution and over-insure rather than under-insure. So if it says the association insures the unit, they're going to insure everything inside that unit except personal property. Because they're not going to go delving into, the fine print that says, well, but the homeowners have to insure the finished surfaces, blah, blah, blah. So most of the time, associations insure a little bit more than they should be. With a maintenance and insurance chart, again, if those are turned over to the association's brokers, then they know exactly what needs to be insured. And then you don't have to worry about being over or underinsured because someone else is trying to interpret a legal document. And of course, if you don't have the maintenance and insurance chart, you're going to call your attorney, you're going to call the insurance rep, but you're going to need to figure out who insures these damaged components. Okay, so that's two of our questions, right? What caused it and what was damaged, and really part B, who insures it. Oh, we have a funny. I'll give you a minute to read that. If you've been in my insurance classes, I usually use this one because it just makes me laugh. So it's more for my entertainment that I use these. You'll probably keep seeing it if you go to more insurance classes. All right. The last question in our analysis. Cost to repair. Is the cost to repair all this stuff, is it higher or lower or equal to the deductible amount? So this obviously means you're going to need to know what the deductible is. Be careful because you usually have two separate deductibles in your property policies. You're going to have the wind hail deductible, which is always not always, but usually a percentage of the value of the buildings. And then you're going to have a dollar amount for the rest of the property claims. That dollar amount can be as low as $1,000. I've seen it as high as 25, 30, 40,000. I think that's a little high. Hopefully you're somewhere between 2,500 and 7,500, somewhere in there. A lot of associations have 10,000. And so kind of the thought being, even if we insure, even if it's a covered loss, if there is $5,000 worth of damage, but we have a $10,000 deductible, we're not going to get anything anyway, right? So we got to know, at least we don't have to know the exact dollar amount, but we should have an approximate idea. Right? So here's the rule of thumb. If the association insures the damaged components and damages were caused by an insurable event, and repair costs are greater than the deductible, association must submit a claim. Now, don't freak out, because a lot of you are saying, well, we wouldn't always do that anyway. We wouldn't submit a claim all the time. We don't want that much in our claims history. So certainly, like I said in the beginning, there's always going to be nuances and things to take into consideration that may cause deviation from the general rules. And so this is not gospel. This is the general rule. So we know we have other considerations to think about. All right, claims history. So yeah, that is a true concern. We all know that the more claims an association submits, the higher the premium gets. We also know that there are associations that have been dropped from their insurance, and then the only insurance they can really get are the secondary lines, which are super, super duper expensive. Plus, every year, it seems like even regular insurance is going up and up and up in price. I mean, insurance is not getting any cheaper. So associations are very concerned about the costs associated with getting insurance, keeping insurance, and rightfully so. That is a huge thing. But what are the consequences of not submitting claims? I think that's really the question. Well, ultimately, if you would have or are likely to have gotten a payout from insurance if you had submitted a claim, if that is the likely outcome, and you say as the association, we are not submitting a claim because we don't want it on our claims history, or we don't think we should have to, I mean, whatever it is, if there would have been an insurance payout, the association is going to have to take that money out of pocket and use it towards repairs. It doesn't matter if we have a repair obligation, if we have an insurance obligation, we're going to have to do that. Because if we had submitted a claim like we were supposed to, insurance would have paid this money. And since we're not submitting a claim, we have to pay this money. So that's kind of the first thing to worry about, is if you're not submitting a claim when you should be, you are probably going to have to write a check for whatever amount insurance would have paid. Next thing, I have seen homeowners, especially now, people are getting more litigious. I've seen homeowners get very upset and run to their attorneys if an association does not submit a claim. The attorneys then turn around and say, you have to submit a claim or we're going to sue you for, breach of your fiduciary duty. Is that a viable claim against the board, against an association? It sure is, because the declaration says we have to insure these things. With the obligation to insure comes the obligation to submit claims when insurance covers those things. So there could also be a breach of fiduciary duty, a breach of contract, which is we're not following our declaration. We're not doing the things we're supposed to be doing as an association. We're not protecting our homeowners, even though we're supposed to be. So there are definitely consequences to not submitting a claim. And I think if you're at the point, or your board is at the point of saying we're not submitting one, you need to, first of all, get an opinion from your attorney as to whether insurance would have likely paid something out. And if the answer is yes, they would have, and this is kind of the ballpark, you're probably going to have to write a check. So important things to consider. And I don't know really whether it's worth it to take the risk, but you're risking it either way, I guess. Deductibles. So deductibles, we could have a 2-hour class just on deductibles. And in fact, next year we are going to have a webinar dedicated to deductibles. So yay, plan on attending that. But deductibles also come into consideration. Usually deductibles are coming into consideration after a claim is submitted and the payout is done, because then we start fighting over, well, who has to pay the rest of these contractor bills, because that's part of the deductible amount. And so I don't think deductibles should really impact your analysis as far as whether or not you are going to submit a claim. right? I think that's an analysis after the fact. All right, what I want to do now is go through 3 examples of insurance type situations and kind of go through them and work through them and see if it makes sense. All right, so example number 1, condominium community and association insures the buildings. All right, so we've got a condominiums, association insures the condominiums, insures the units. Owner smokes in bed. This is just like an example I gave you earlier. Owner smokes in bed and does not put out his cigarette, which causes a fire and damages only that owner's unit. Total damage, $10,000. Deductible is $5,000. This one should be a no-brainer, right? If you're thinking, yes, they have to submit a claim or they have to pay $5,000 out of pocket, you're absolutely right. This one, the only thing that you got to remember with this one is, yes, the homeowner was clearly negligent and caused the fire. And yes, the fire only damaged that owner's unit, but the association still has an obligation to insure that unit. And there is an amount that would be paid out by insurance, approximately $5,000 after the deductible is taken out. And so the association does have a duty to submit the claim, or at a minimum, pay for $5,000 worth of the damages. Now, I do want to bring one little thing up because it does come up over and over again. And it's not as much related to whether or not to submit a claim, but what an association does with the money it receives from insurance after a claim is submitted. If you are a post-Kiowa community, so created after July 1, 1992, you cannot distribute that money directly to the homeowners. Okay? There's a specific provision in Kiowa that says any proceeds that are given by the insurance carrier to the association must be held in trust and must be distributed to pay for repairs. And cannot be distributed to owners. It specifically says cannot distribute them to owners unless there's a surplus. I have yet to see a situation where there was a surplus of insurance proceeds. It just doesn't happen for the most part. So most likely you're not going to have that situation, which means all the money that the association receives when it submits a claim has to go to pay for the damages. So a lot of times you're going to have homeowners approach you and say, well, give me the money and I'll pay my contractor. Not going to work. So if it's a homeowner contractor that did the work, if it works out that way, then you could request a copy of the invoice and issue a check directly to the contractor. You could do it that way. But the money, should not be turned over to the homeowner. And this happens a lot where the homeowner's like, just give me the money. I want to do some upgrades and I'm just going to take the money and use it towards repairs. And associations are like, okay, no problem. We don't care. We don't want to deal with this. But for a post-Kiowa community, you can't do that. So be very careful when you have insurance proceeds in your hands and the homeowner's approaching you saying, just give me the money because I want to do extra stuff. Can't do it. Let's look at the second example. Townhome community, and the association insures the residential structures, including the interior drywall and finished surfaces. Due to the age of the buildings, lots of cracks start appearing inside the units, and there's concern over the structural integrity. Owners demand the association repair all the structures, which would cost over $100,000. Deductible is $5,000. All right. So I think there's 2 things going on here. Let's first take a look at, if we go through our questions, the first question is, what caused the damage? In this case, age of the buildings. Age of the buildings is going to fall under wear and tear. Unless there's some additional event that either contributed to or completely, overshadowed the age of the buildings and destroyed them, you're not going to see coverage from your property policy because they're going to say it's wear and tear. So is the rest of the stuff in this example even pertinent? Well, with respect to the claim submission analysis, I don't think it is, right? Even though we insure the structures and there might be structural issues, it's not a covered loss. And so if we turn a claim into insurance under these circumstances, you're not going to get anything. It's going to be denied on the basis that this is not an insurable event. You get nothing. Now, the flip side of this, though, is owners are still demanding the association repair the structures. I think that is a separate analysis from whether or not we submit a claim. There may still be a duty to repair if the association has the maintenance and repair obligations for the residences. We don't know from this example, but I think the key, the takeaway is we don't have to submit a claim, but that doesn't mean we should not be looking into whether the association has an obligation to actually make the repairs. Okay, so that's kind of the difference with this one. And because they're townhomes, right, they're not condominiums. The townhomes are all like the full residence belongs to the homeowner. So no portion of the residence is really going to be a common element that we are obligated to maintain. We have to look at the declaration to determine whether or not the association has any maintenance or repair obligations with respect to the residences. So just because we have to insure doesn't mean we have to maintain and repair. Let's do another example here. Townhome community, owners insure their homes. Due to drainage issues, many units are experiencing flooding, and owners are demanding that the association pay for the repairs and damage to the property because it maintains the drainage. Should this association submit a property claim? Should the association submit a liability claim? Okay, so this one touches on both property and liability claim submissions. Let's go through our analysis. So what caused the damage? Flooding. Okay, flooding. Is flooding an insurable event? It could be if you have flood insurance. Generally, in a regular property policy, groundwater is excluded from coverage. If you get an additional flood policy, you may have some of it covered. So we can say maybe it is an insurable event. We don't know. We don't know if flood insurance is being carried here. Okay, so let's go to the next question. What is damaged and who has to insure it? Well, let's see. It says owners demand that the association repair their units. So it's the units. Right? It's the units that have damage. We don't know exactly which components in the units, but we know it's part of the units that have damage. Now the first sentence says that the townhome community and the owners have to insure their homes. The owners are responsible for their own insurance. So the units, the homes, same thing, right? So the homeowners insure their homes. So any flood damage, if there's insurance for it, would have to be carried by the homeowners. So, okay, we don't insure whatever was damaged. And so you can stop the analysis right there and say, okay, we're not submitting a claim because we don't insure the damaged components. The homeowners insure that, and the homeowners need to submit a claim. However, we have another question, and that is, should the association submit a liability claim? So where's the liability? Well, the homeowners are demanding that the association make the repairs inside their homes because they are responsible for drainage. So whether it's, it's coming from common area or whatever, the association has to maintain appropriate drainage. And kind of the unspoken allegation here is you didn't maintain it properly, association, which is why my unit had flooding, right? I mean, they didn't come out and say it, but they may as well. So do we submit a liability claim under this particular scenario? Well, it's probably a little bit early to submit a liability claim because, one, we said before, has there been a lawsuit? There has not been a lawsuit. Right now, we just have homeowners demanding things. And if we submitted claims every time someone demanded something, I think that would not be good for the association, because that's work that your insurance has to do. Even if they don't pay anything out, they're still going to have to do something with it, and that's going to be a little red check mark against you of submitting a claim. So we want to be very careful. So I would say no, we don't want to submit a claim yet. When would we submit the claim? When we got sued and served. If the homeowners retain an attorney who reaches out and says, I'm going to sue you if you don't repair this for my clients. At that point, we might turn that over to insurance, and not as a claim, but to say, hey, this is a potential claim if we get sued, heads up, right? It's not a claim yet. They're not going to do anything with it yet. But once the lawsuit comes, now it's a claim. But certainly, there's no reason to submit anything to liability before there's even an attorney involved on the other side. That would definitely be premature, okay? So again, this is a good example of we would not submit a claim under property because we don't insure the damaged components, and we would not yet submit a claim under liability because we do not have a claim yet, but is there a potential claim if they get an attorney and they sue? Hopefully that makes sense. Yes, insurance claims. We are ready for some questions. While we have questions, I'm going to have you watch the dancing pig and the dancing duck. I am going to turn over. All right. Did you see my question about subrogation and victim impact statements? I did not see that. Can you redo that? Or maybe this is it next. Sorry. We had, hold on a second here. All right. We had an insured driver go through a townhouse. Lovely. We filed a claim for the structure damage, and it was denied because it was less than the deductible. Okay. The homeowner filed victim impact statement with the court for interior damage. Since the HOA had to subrogate the vehicle owner for the structural damage, should the HOA also submit a victim impact statement? So I don't think it would hurt to submit one. A victim impact statement is something that would get submitted if this is a criminal case, like someone was drunk driving and it's become a criminal case. A lot of times the victim's advocacy department, they can try and collect on damages if you submit that kind of a statement. I've had associations submit those statements, and sometimes they get some money, sometimes they don't, but it's basically you know, the state or the county collecting on your behalf because you're the victim. So I think it doesn't hurt to submit one. I wouldn't rely on it as far as, you know, oh, now we're going to get paid, but I certainly think it would not be, you know, it wouldn't hurt the association to submit it. All right, next question. All right. In the slip and fall injury or related injury, if the slip and fall injury costs less than the deductible, should a claim be filed? Okay, well, if it's less than the deductible, probably not. But in most cases, if you actually look at the, it's called the declarations page. It's that front page of the policy that kind of summarizes everything for you. Most of the time, what we find in the liability policies is the deductibles are very small. $500, sometimes less. They're usually very small, and medical bills tend to be very large. So most of the time, I don't think you're going to be in a situation where that happens. Sometimes for certain types of liability claims, there are no deductibles at all. Like sometimes with medical bills, there's, you know, the deductible doesn't come into play. So I would probably submit it anyway, or at least check with your insurance agent, broker, as far as what would be the deductible for this type of a medical bill claim, because my guess is it's going to be pretty low. Okay, so is it common for major irrigation repairs to not be covered by insurance? Recent boring repairs resulted in $50,000 expense to association to replace many severed lines. Already tried pursuing boring vendor for damages to no avail. So board asked that we submit a claim through HOA's policy, but insurance agent advised irrigation repairs are not covered under the policy. Yeah, a lot of times that would be a standard exclusion under the policy, and it's something that you may or may not be able to get additional coverage for. I can't tell you, but sometimes those things are excluded. A lot of times certain types of landscaping is going to be excluded. Concrete is generally excluded from coverage. So sometimes an association does have an obligation to insure something, but you know, property-wise, but you can't really insure it because it's not something that you can insure. So like I said, the concrete foundations are not generally insurable, especially in Colorado. So things like that, you're not going to be able to insure. And if that's the case, then obviously submitting a claim would be useless because you're not going to get anything out of it. But I certainly think it's a good idea to at least try to get something out of the contractor. Sounds like a breach of contract, a negligence issue. If you have a copy of the certificate of insurance for your contractor, which hopefully you're all getting, then you would be able to go directly to that contractor's insurance and submit a claim, which is why we recommend getting the insurance certificates, actually, that name the association as an additional insured. I'm going to see Florida. Would this be a liability claim? It's a good question. I honestly, to tell you, I haven't really wanted to delve into it, and I purposely am kind of not reading about it. So I don't know for sure because I don't really have all the facts because I'm trying not to have all the facts. It could be. I've heard limited things. I don't feel like I have enough information to tell you if it could be a liability claim. I mean, obviously somebody filed a lawsuit and it is based on liability. And so we'll see where that goes. In my opinion, that was completely premature, but it could be. It could be. In the case where a person smoked in bed, caused $10,000 worth of damage that is covered by the association insurance, what type of language do you need to have in the bylaws or the rules and regulations to make certain owner has to pay the deductible? Well, the good news is if you are a post-1992 community, Kiowa has language that says deductibles can always be assessed to the negligent homeowner, regardless of anything else. So if you're post-1992, even if your documents don't say it, Kiowa does say it. So if a homeowner was negligent, they caused the fire, the deductible can be assessed to them. Otherwise, most community declarations have language that talks about homeowner negligence, that if there's any damage caused by homeowner's negligence or a willful action, that that homeowner is responsible for the damage. Well, that can be applied to the deductible as well, because that is still money that would be coming out of the association's pocket to pay, to repair. So the association would still be able to assess that amount of money back to that homeowner. Let's see. Owner left water running and went to work. Damage to unit below him, pre-Kiowa, okay, is this HOA insurance? Owner who left water running or owner whose unit was damaged? I think, well, it's hard to say without looking at their declaration and knowing whether this is a condominium, sounds like a condominium community, but I don't want to assume that it is. Depending on who insures what and what your declaration says, sometimes it's every party for themselves. And if each homeowner insures their own unit on the inside and that's where the damages are, then arguably each one of them would have to file their own insurance claim. And then their insurance carriers could go after the other homeowner that they believe was negligent. But unfortunately, the answer is it depends. It's hard to say without, looking at the documents. How do you know if it's negligence? How is that defined for insurance purposes? That is a great question. And I don't have a short answer on that because negligence is a whole legal analysis, which, by the way, we will also have a webinar on next year. And basically, the very short form of the legal analysis for negligence is someone had a duty, someone breached that duty, and because of the breach, directly because of the breach, there were damages. That's really the analysis the courts would go through. So I had a duty to maintain the roof as an association. I did not properly maintain the roof. Because I failed to properly maintain the roof, there was water damage inside the unit. Damn, that would be negligence. But it's a very complicated analysis. And it is going to warrant a whole class, but that's just the gist of it. Owner, well, let's see what time it is. Okay, we got some time. Owner who knew they needed new pipes pre-Kiowa has a leak that affects the lower unit. Would they be found negligent and responsible for all costs? I don't know. I would have a lot of questions as far as, is the homeowner actually responsible for replacing the pipes? Are we sure it's the homeowner, not the association? Is this a condominium community? What does the association insure? The answer is really all going to be dependent on those types of questions. And when you have something that specific, you are most likely going to need to go to your current legal counsel to look at everything and give you kind of their legal analysis of it. Without looking at things, I can't give you just an answer like that. I'm sorry. Upstairs owner had water shut off that failed and did damage to the unit below, costing thousands. Insurance claim went through the owner's insurance policy as they were advised the HOA would not cover the damage. Okay, so that may be good or it may be bad because if it's something the association should have covered, which I can't tell you if it is or isn't, you are going to be getting something from the homeowner's insurance company subrogating against the association, saying, no, you guys should have paid for this, and you need to pay us back. I've seen that happen time and time again. When that happens, obviously the association is probably going to take that demand, turn it over to its insurance, and hope that the two insurance companies fight it out. However, without looking at your insurance policy, I can't tell you, what your insurance carrier is going to do. Be careful with not submitting claims because homeowners will go to their carriers and sometimes carriers will pay and then go after the association. So don't assume it's all over. Now, if this happened 5 years ago, then yeah, it's over. Don't worry about it. But if this is something fairly recent, just keep your eyes open for any kind of demand that may be made by the homeowner's insurance. All right. So this is, we're at the end. I think we got through all the questions. If for some reason I didn't get through your questions, you see my email, feel free to shoot me an email and I'll try to get back to you as soon as I can. But otherwise, thank you guys so much for being in on this webinar, and we will see you next time. Hope everyone has a great day. Thank you.